Hey guys, and welcome to Chapter 8. This is going to be an overview of criminal justice in Victorian America. And we're talking about a period of time from roughly 1870 to 1901. And what I think I'd like to get out of this particular chapter is to understand the various reform movements that took place during this era. Especially those that focused on juveniles and the juvenile court system, our view on vices as a society, some level of police professionalism was becoming evident, especially in large urban areas such as New York City, and the change in correctional reform. And much of this change was reflected in how we treated women in terms of providing them with correctional facilities just for women, because prior to a lot of this movement, women were incarcerated with men. So this allowed a whole change in philosophy in terms of society's view on how women should be dealt with and punished in terms of the criminal justice system. All right, so I think those are some of the key things to hopefully you'll glean out of this particular short lecture. So you can take a look at the learning outcomes in this version, as well as the non-lecture version that's also posted in the discussion boards. You can take a look at either one of those, and you can read that for yourself. As part of the introduction, just understand that we're still dealing with that era after the Civil War, and we're talking about, again, the 13th Amendment in terms of the abolition of slavery. But in terms of an overview, this gives you a sense of some of the topics that were taking place during this particular era, all right, as a matter of an introduction. So you could take a look at that and read this for yourself, some of the things we talked about in the previous lecture as well. Now, major cities in the North and the South were adopting new police technology and strategies, even though this was still a relatively, you might not look at it in terms of technology, but when we're talking about the telephone and the telegraph and the implementation of those type of systems, police began to embrace and understand and how to use this technology for their benefit. So it allowed us to be a little bit more efficient and perhaps a little bit more effective. All right. But just understand the technology was beginning to take place during this time period. But obviously not to the extent that you and I might think today. But, you know, some of the basic types of systems that were coming into place were being used by police during this period of time. And so, you know, police began to use this type of technology. And one of the ones that is mentioned in the book is the Bertillon system. And this was basically a complicated identification system of measurements that was created in France. And it was designed originally to identify recidivist offenders. And it was eventually replaced by something that is still very common in use today, and that is fingerprints. Also, during this period of time, there's a Victorian compromise. Private sins could be tolerated in the dark corners and back alleys as long as public order was not compromised. And so here we're talking about, you know, typically we might look at this in terms of gambling and prostitution and those type of things. All right. You know, so over in this corner, here's some food for thought as it relates to certain vices and prostitution and gambling. And these are issues that we're still dealing with today. Is it possible to police morality, you know, as it relates to certain types of offenses? And here again, we're talking about prostitution, gambling, those type of things. So is it possible to police morality? And there's a lot of complicated facts that go along with that, and a lot of complicated problems that go along with that. And we're going to learn about some of those problems when we talk about prohibition. Because how do you enforce a thing like prohibition and not encourage, to some level, police misconduct? And you'll find that during the prohibition period, we had a significant amount of police corruption in a lot of our major cities, Chicago, for example, and even in New York. So understand that these type of offenses that public has long tried to control can be, in fact, very difficult to enforce. So we talk about certain things that occurred post-Civil War era. We saw a substantial number of cases dealing with criminal due rights and constitutional protection of the Bill of Rights, coinciding with the expansion of federal criminal law. So as we began to establish laws, for example, we talked about them to reflect the assimilation of blacks into society in terms of the ability to vote, anti-discrimination, those type of things. You're going to again begin to see a increase in the expansion of federal law and federal law enforcement. And this is especially going to be relevant in the South as we began to try to enforce some of these constitutional amendments, these federal laws that were a result of actions of Congress following the Civil War. In one case, Bradwell versus Illinois decided that equal protection clause of the 14th Amendment only applied to men. So again, we're beginning to see an era where women are still marginalized in our society. But as we will begin to see here in the not too distant future, this began to change with the 19th Amendment. But nonetheless, the whole idea that women were subservient to men was still a common theme, especially in this period of time. Initially, the Bill of Rights didn't apply to the states by federal courts. For example, the Fourth Amendment, the First Amendment, the Sixth and Fifth Amendment, so forth, they were not applicable to the states according to federal courts. And again, this later changed, but this didn't change until the early 1960s. So federal Bill of Rights, as we know them today, were not applicable to states. So states, federal government couldn't come in and tell states that they had to apply these statutes because that was the determination of federal courts. When you're looking at some of the other key issues in the South, Southern lawmakers framed new legal codes to regulate the former slave. We talked about the black codes, peculiarity, black crimes, vagrancy, rape, arson, burglary, those type of things. So again, the South was still having difficulty adjusting to an era following the 13th Amendment, and oftentimes created laws specifically to marginalize black society. In Plessy versus Ferguson, which was an interesting case, this had to do with discrimination and segregation based on blacks and whites on a train. Plessy elected to sit in the white part of the train and was subsequently arrested and charged with the Louisiana statute. The United States Supreme Court approved a separate but equal clause holding that segregation was not unconstitutional as long as the facilities were equal to those of whites. This was a law up until about the 1950s, in which the Supreme Court later changed that in Brown versus Board of Education. So even the Supreme Court of this country at one point believed that it was okay to have separate but equal facilities for blacks and whites. Comstock laws was passed as a result of what was referred to at the time as penny press, which was an urban newspaper that was a source of cheap advertisement for abortion-related advertisements. So again, we're beginning to see the role of especially federal government, Congress, and the federal judiciary in trying to control things such as, in this case, obscenity. Basically, in 1873, Congress passed the Comstock Law, which prohibited the mailing of art, literature, and other materials considered obscene by the U.S. postal agent. Anthony Comstock, who crusaded to make birth control and abortion illegal in the United States. So we began to see where laws were used as a means to possibly enforce one's personal beliefs if one had the influence. And this will come back up again during the Prohibition argument in the Prohibition era, because this was a federal law. And obviously, enough women were able to influence enough members of Congress to change the law to make prohibition illegal in the United States. So understanding that, I think, is important. But again, obscenity is one of those things that, it's hard to define. I think one Supreme Court justice said, obscenity is hard to find, but I'll recognize it when I see it. So again, trying to enforce these type of laws and statutes began to take place during this period and era of time. Law enforcement began between 1870 and 1900. Most large American cities had established professional police forces. There was a vacuum in terms of leadership in policing that led to a creation of vigilante groups, and this is most often in rural or less populated areas. So those areas didn't have quite the level of policing that we're accustomed to in this particular time period, and those were obviously in big urban areas. So less populated areas was more of policing by vigilante. Lack of policing resulted in use of militia instead of national armed forces. So again, those areas of the country that didn't have sufficient policing, we began to see the military or militia as a key enforcer of laws. Major city police forces saw reform efforts from local politicians, state legislatures, and police chiefs. So we began to slowly start to see a change in a movement toward a more positive reform. This would later cause some problems, as we will learn, when politics and politicians had an incredible amount of influence over policing. And that caused an array of problems that you'll read about here in not too distant future. You can read about federal law, but again, following the Civil War, the belief that criminal law was a state matter, not a federal one, still persisted, especially in the South. And then Congress passed federal laws that proportionally targeted the South and the West, because the South, because of the issues associated with the 13th Amendment, and the West in terms of the fact that the West still was unruly and was sort of, in terms of law enforcement, rather chaotic. You can read about the New York City Police Department. I'm not going to go into a whole lot of detail here, but you can read about the Lexow Committee, and get a good understanding as to the measures that then Mayor Roosevelt, later became President Roosevelt, applied, some of which are applicable and continue to this very day. And one of his, obviously a big push was some level of a background check to ensure that the person seeking the job is one that should have the job. Okay, he sort of meets the criteria for policing. So he established numerous reform measures. So you can read about those. And then the Lexow Committee and its standards for hiring police officers is covered on pages 172 to 173. So you can read about that reform. So again, these are potential topics for your paper as well. I'm not going to talk about the Pinkertons, other than the fact that big business began to use private security as a means to deal with employees who went on strike, and often led to bloody conflict with organized labor, and you'll read about that. Criminal identification, again, the use of technology during this time period. Page 177 has a lot more information on it, but understand that law enforcement began to use this type of technology as we progress forward. You can take a look at professionalism. Again, the International Association of Chiefs of Police, dealing with the whole concept of professionalism. Southern policing, again, I'm going to talk about that in just a minute, but I'm going to run out of time here, so I'm going to stop here, and then I'm going to continue in part number 2 for this lecture in just a little bit. Okay, so I'll see you in just a sec.